Ready? Start. Cognizant of the fact that the fate of instant case is hanging in balance and its trial has yet not commenced due to jurisdictional controversy between the courts constituted under ATA 1997 and CNS Act 1997, thus we intend to restrict ourselves to the extent of forum of trial and feel no need to dilate upon the merits of acquisitions full stop. In the given circumstances, primarily we are confronted with the proposition that the fate of acquisitions is to be decided by one common forum or to be tried separately by the courts constituted under ATA 1997 and CNS Act 1997 full stop. The trial commences from the taking of cognizance, which is generally described as the stage when the court applies its mind by framing a charge against accused full stop. Para. The language of section 235 CRPC is explicit in sense and enables a court to charge an accused in one trial for multiple offences comprising upon different acts but committed during same transaction full stop. The same transaction used in section 235 CRPC is of dominant importance and calls for our indulgence full stop. In our view, the offences, though committed not at same place and time, but if are stemming from common motivation, intent, design or in continuity with each other, still can be described as forming same transaction full stop. For the determination of question about the offences having been committed during same transaction, the root cause of the crime or the motive is to be considered along with the proximity of time and distance between the different events full stop. To be precise, if the different events forming basis of a crime cannot be bisected in reference to the motive, design, concert and reasons, rather are strongly interwoven with each other by common thread of background, it can inexorably be held that offences are committed during same transaction within the meaning of section 235 CRPC full stop. The foregoing provision from simple recital is found to be specific as it deals with multiple offences committed by a single accused in a series of acts tied with common note so as to form same transaction full stop. In the instant case, three persons are clubbed together with the allegation of having committed different offences during same transaction full stop. Section 239 CRPC caters the proposition of joint trial in cases wherein two or more accused are burdened with the allegation of having committed different offences during same transaction full stop. Para. Apparently, the wisdom behind concept of joinder of charges arising from the provision of chapter 19 of CRPC is firstly to avoid conflicting decisions and secondly to save the witnesses from the ordeal of appearing in the dock repeatedly for deposing about offences committed in same transaction, and thirdly to save the time of courts by clubbing different connected offences in a single trial full stop. The facts of the instant case when tested on the touchstone of above discussion lead us to an irresistible conclusion that different offences were committed in the community of object, purpose and in continuity of actions full stop. All the accused, namely in the crime report prima facie, were found concerned in drugs trafficking and one out of them committed the murder of a person hailing from raiding party to make an escape and to avoid arrest full stop. Beyond scintilla of an ambiguity, all the offences are committed in one transaction, thus are to be tried through a common charge under section 239 into D CRPC by the same court in a single trial full stop.